All right, well, welcome back to our Corecast. Again, with me, Tommy Strelka, an attorney here in town with employment law, Lynda McNutt Foster with Cortex Leadership, and we are talking about the new white-collar law. We've talked about it. Basically, it deals with overtime. And Tommy, I'll talk to you first, too. I think a lot of people think, oh, this is a problem for the leaders. This is a problem for management. But it's not. It really affects everyone.
That's correct. It does affect everyone. First of all, there's so many misperceptions about this law and about what I've run into in Roanoke. There's this kind of it's less frequent this line of thinking, but there is a line of thought that if you just pay your employee a salary, then they're exempt from overtime, and if they work 50 hours a week, you don't have to pay them anymore. Well, that's not true. If they don't fall into an exemption, then they're not owed time and a half for every hour after that 40, but they are owed half time, which means you have to then do some math to figure out what their annual salary breaks down to at an hourly rate and then get those other hours. But as far as it affecting people, let me just give an example of how quickly this domino falls and how quickly everything else does after that. So in almost every other type of employment law, you have to first pursue, before you can just file a lawsuit, you have to first pursue some sort of administrative remedy, an investigation with the EEOC or Department of Labor. You don't need that with the FLSA. You can walk in the next day and file your lawsuit. Not only can you file your lawsuit the next day, it can be for as little as $1 that was owed to you. But it's not just for you. Virginia doesn't allow class actions. We're in federal law. The FLSA, it's not called a class action, but it's the same thing. It's called a collective action. So that $1 unpaid employee can walk in and set off a lawsuit that not only covers he or she, but every other employee that worked that was similarly situated, doesn't even have to have the same title, but did similar job duties as that employee for the past 3 years previous. And so
is anyone breaking out in hives yet? If you own a business, I mean, I'm quite serious to say, as a business owner and one that's been in business for many, many years now and started businesses. I think you get my little face is getting
it is.
you
are a little flush.
I mean, from a business owner perspective, I'm like, oh my gosh. How in the world are our clients going to manage this moving forward is really the question. How is email going to work? Honest to God. Right. How is email going to work for our clients and employees?
He's like,
yeah. This is,
you're going to be busy.
Right, you're going to be, you're ready for an avalanche. You need to hire 4 people.
I'll let you know, I am a small business owner myself, and the FLSA scares the dickens out of me. It scares the absolute dickens out of me.
Thank you.
I'm ever vigilant and ever wary about how many hours my employees are working, because this stuff applies to them. And I'm walking around the office all day talking about the FLSA law. I mean, people are listening, so I would make sure. No, it's definitely a fear. But I'll tell you that one of the issues seems to be, as it relates to how these cases pan out, they tend to have a quick settlement is really what happens, because the thought of opening up the case, there is a period of time by which it's a couple months before the judge will allow all of the other employees to join in. And usually what occurs is that the employer settles with that employee. And I could say that, well, they fight it and they dismiss it. Dismissals are rare under the FLSA. And that's because there are so many regulations and there's so many differing court opinions on this, that, or the other, all these very over-legislated pieces of statute, that it's cloudy, it's murky, it's arguable. Everything's arguable. And if it's arguable, that means the attorneys can have a field day and just go on and on and on and on and on while the attorney's fees just increase. And don't forget, if the plaintiff wins, the employer owes the plaintiff all of the plaintiff's attorney's fees. So, the plaintiff's attorney submits a bill to the court, which usually, I think the going rate right now is around $300 an hour for every hour that the attorney works, and that's going to be over 6 figures if it goes all the way through.
So let me just, you mind?
Can you speak? Are you okay? Should I throw some cold water at her? How you doing, Lynda?
So let me give you a very common scenario for my clients. 8 to 5, totally slammed. Back-to-back meetings, in meetings all day long. They get off at 5 o'clock. By 6 o'clock, they're hammering email out to employees because they need to communicate to them then. They don't have time during the day to handle a lot of leaders, their administrative stuff. They do it at nights. They do it at weekends. That lands in an employee's box. That employee responds to that email. What is that? What is that like? Because that's business right now.
Sure, that
Right.
is business because of the speed of technology. You have to be accessible, and so the business itself needs to figure out the cost-benefit analysis of having that accessible employee. The first question the business needs to ask is that employee exempt? Because the new rule sets a salary cap at $47,476, which means that if the employee, who let's say is an administrative employee, is earning less than that, then they're not going to be exempt. They're going to be salary. They're going to be presumed to have overtime. As long as there's also a duties list, checklist, which is not overly complicated, but I'm not going to go into it now because this expansion of the salary, the level used to be 23,000, just over 23,000,
Right.
and now it's at close to 50. And so the Obama administration estimates that for each year that this will be enacted, that over $1 billion in extra money will be given from United States companies to their workforce that just fall within this exemption now, or don't fall within the exemption rather. So the options for the company are either, we either make it a mandatory policy that no one works more than 40 hours a week, which you can do. You can say no overtime. If someone actually does work overtime, you do have to pay it, but you can fire somebody for working overtime. If you have a policy that says this company does not operate on overtime, that's legit. Okay, so that's one option. The other option is you start adjusting salaries. You start thinking about if someone's now going to be exempt, do you give them now not going to be exempt, do you give them a bump in pay so that they're now going to be above that 47,476 and now they're going to be considered to be exempt? You know what I mean? Do you take your $30,000, $35,000 administrative assistant and give him a raise to $50,000 so that you have access to that person
So you
at
can
hour
email
50?
at will.
So you can email at will.
At will.
At will.
So if they're on salary, you can email at will.
Not necessarily. They
If
have to
it's-
be on salary and exempt. They have to be
On salary.
Yeah, I have to be on
Over
salary.
47.
So if it's
Over
40,000 salary, they still
40
get overtime.
It's 47,000 salary, and they still get overtime.
Right.
Now, there's this additional test I'm just going to mention because it's just so fun and lawyerly to say. But they also have to have to be able to exercise discretionary control over matters of substantial importance, or
Right.
So that is
What?
exactly to fall in the exemption. But basically, that means having a lot of discretionary authority, one that is typically more vested in someone in supervisory role or executive role. So most office workers don't pass that, and most office workers who are making under $47,000 would be owed overtime after this.
So, but let me just in small business terms, and that, I represent a lot of big businesses, but in a small business term, I've employed a lot of millennials in the last 4 years, and the way the millennials love to work is sort of give me the work, let me get my task done, and whenever that is, and they email me at 10 o'clock at night sometimes, or email me back, and those type of things. Under this law, what happens to the freedom of these young workers who want this lifestyle, which I'd love to give them, but I don't know as an employer how to make that happen under what you're talking about.
Right.
And I don't want to pay him. I can't pay him $47,000 to every
Understood.
one of them $47,000, and they wouldn't even match it because they wouldn't have control over the description you just had.
She's not
Not
breathing,
fit.
Tommy.
Yeah, I understand. I understand.
I can assure
I'm
you
feeling
right
it.
now that
She's
there are
not
business
breathing.
owners out there right now that are listening to every word of this question because
Yeah.
we're going, how do we actually tell me how to do this?
Right. So, with the hypothetical millennial that you're speaking of who, wants to be multitasking at all times, working at odd hours and with freedom, if they truly fall below this new salary threshold, then the freedom, unfortunately, would have to be quantified. You got to be able to break it down and figure out anytime that they're actually doing anything related to work. If it's a 3 a.m. email that has to be tabulated, it could be that they you now have to log in through a system anytime that you ever want to perform any task related to work. Just as we have freedom of technology, technology can fence us in as much as we want to. And you can have, Big Brother type software applications put on phones and other things. You can make these policies at work so that employee hours can be better tracked. If you have policies that state very clear terms that employees may work at home, off the clock, so to speak, as long as they log in and to the application so that some time may be tabulated, and that employee then screws that up and is working off the clock, they don't have a case. That's not an employee has a case.
Okay.
If you have a system in place and you have clear rules of how that system is supposed to be used to tabulate overtime, and they're not doing it, and they're through their own negligence, then that's not a case that anyone's going to take.
Okay, I took a deep breath. That's good. Look, yeah, the Reds.
Because we're going to need to wrap this up right here pretty soon. I do have one question, and of course yours is to practice law, not to make it. But if you know the answer to this, either of you really, why was this law, what was the purpose of putting this into effect in the first place?
Well, there's, this push and shove in the country right now very much over minimum wage, which is also governed by the FLSA. And the Department of Labor is an executive agency. That's an agency that has run under the authority of the president. And this president that we currently have has been exercising authority in more creative and interesting ways, to say it in one way, than past administrations. And I believe that this is me speculating here from what I've read and so forth, that with the pushback of trying to get more pay to workers in the United States through minimum wage being too much of an uphill battle, that there could be regulatory changes that the Department of Labor could make and did make that would then allow additional pay to be coming from companies to America's, quote unquote, middle and lower middle class working population. So that's what I think happened. I think it was kind of a back door to opening up more funds to the employees.
And is the idea to get the economy going then, because people make more money, they spend more money?
If that is the idea, but that is about as divisive as an idea as anything could be.
So what do you see before we wrap this up in the coming months, especially the first few months after this goes into effect? I mean, what are you envisioning for your job right now?
I have a flurry of people contacting me wanting to know where they stand and whether they have a case, whether they can file one, or whether the one's going to be filed against them. I mean, to be honest, anytime there's a change in the law like this, there's going to be a flurry of activity. But when you start with a law that's already so complicated and messy and sticky and just a big old bag of thorns, and you add in this change that's going to flood in, essentially, a whole bunch of new people who are now entitled to overtime. And the way you even get to that conclusion is confusing to begin with. Yeah, there's going to be lots of mistakes that people are going to make from the employee and employer side. And that just is going to mean attorneys are going to be busy.
What?
I was just looking at you to make sure you were breathing.
I'm breathing.
Do you have any final thoughts that don't last an hour?
Well,
a quick
I
thought.
think we're gonna. Well, I think we're gonna talk about it on this Sunday night.
Yes.
Yeah, newscast. But I think what's really important from a leadership perspective is there's a whole space of morale that the leader needs to consider with this law. So as you bump this one person up from 40,000 to 47,000, so you don't have to do this
47.6, is that the exact
47?
number?
Yeah, 6. Once you bump that up, what happens to everybody else who was already there?
Sure.
How the morale, if you look at the law when they did it in California a few years ago, what happened with morale when I was on salary, and that was important to me, and I worked my entire career to be on salary, and now I'm hourly again. And my hourly wasn't in our heads when we work. We go, okay, we work 80 hours a week, but in our head when we think of our salary, we divide it by 40. But our employer is going to divide it by 80 so that we can be sure that the employers aren't paying. So I think from a leadership perspective, it's really important for leaders listening to understand that how this law is communicated, how it is cascaded through your company and communicated to you and by every person that's communicating it for you is very important moving forward.
That's a brilliant point what you just made, because The law only concerns itself with the dollars and whether or not you are owed these dollars, but nothing about the morale and nothing about the proper application of this kind of thing at the workplace. And that what you're saying is so true, because if you're adjusting anyone's salaries, it's going to have ripple effects around every other staff member. And that's something that the business leaders have to cope with.
Right.
Very good. Tommy Strelka, thank you very much.
Thank
Lynda
you.
McNutt Foster, thank you very much. A lot more to hear on this topic to come, and it goes through December 1st. All right. Thanks for joining us.